Now, it's the challenge of a lifetime, isn't it? Reforming the machinery of Nigeria's justice system in a country where the crimes of those who are supposed to be the custodians of the law explode the limits of the law. It's a country where the justice system, from law enforcement to the judiciary, struggles to encompass and restrain the lawlessness and violence of those who are supposed to be the ultimate upholders and defenders of the law. Take politicians, for example. It seems monumentally difficult, if not impossible, to subject them to principles of justice that notionally transcend political boundaries. But it is to those same politicians that we must turn to reform the machinery of justice. And this week, President Tinubu promised to put his shoulder to the wheel. Speaking at this year's Summit on Justice, Mr. Tinubu, who was represented by Vice President Kashim Shettima, charged the judiciary to embark on fundamental reforms, insisting that without it, Nigeria will never get out of the political and economic mess it is in.
For all justice sector institutions is how to address the general feeling of frustration that the justice system is unresponsive to the needs of Nigerians. In the light of this, I call on all justice sector institutions and professionals to align your activities with the tenets of our renewed hope agenda, particularly as it relates to the priorities on inclusivity, fairness, rule of law, and anti-corruption stance, among other things.
Finally, we must try and curb the misuse of ex parte orders in political matters, particularly by our judges, by the judiciary. To curb this, it is imperative that the National Judicial Council, the NJC, exercises stringent oversight. We recommend prompt and decisive punishment. I was going to say for judges, but maybe for the officers involved, who are found to abuse this authority in any manner.
Access to justice remains a distant reality for far too many Nigerians, with barriers ranging from procedural complexities to socio-economic disparities. The quest for justice should not be a privilege reserved for the few, but a right accessible to all.
And that's the Chief Justice of Nigeria. Before him, the President of the Nigerian Senate, and before him, Nigeria's Vice President. Well, Jibrin Samuel Okutepa is a senior advocate of Nigeria and a keen supporter of the cause of judicial reform. He's written and spoken prolifically about the issue, and he joins me now in the studio. Thank you very much indeed for coming in.
Thank you, Charles, for this privilege, the opportunity for us to discuss the future of Nigeria.
Well, before we start discussing it, I've got to say I like your bow tie, by the way.
Yes, I decided to come in the...
It's very patriotic
in the national colors of Nigeria, because the duty is for all of us to make Nigeria work. And Nigeria will never work if we don't speak the truth. So we must speak the truth, and truth we must speak, so that those who have ears to hear will hear.
That is why we always like to bring you in, because we know you will be unequivocal in speaking that truth. So let me start by asking you this. How would you describe the machinery of justice in Nigeria at the moment, or would even suggesting that such a machinery exists be to flatter it a little bit?
Well, first, before I answer your question, let me commend the Honorable, the Attorney General of the Federation, for the step he took to organize this, what they call Justice Summit 2024, where we saw who is who in that gathering that ended today. It's a good step. For me, the idea of that conference presupposes and acknowledged that all is not well with our justice system. And so, like I said, in my write-up yesterday, I think virtually everyone that had gathered at that occasion, be they in the executive, in the legislature, or in the judiciary, are responsible, either directly or indirectly, for the comatose state of affair of our judicial system that we find ourselves today. And so I had said that there is nothing inherently wrong with our laws. What is wrong is the operators or are the operators of our laws. And I hold the view, and very strongly too, that if we are honest with ourselves, Nigerian does not operate the rule of law. What we operate is the rule of convenience. And virtually, like in your intro, everyone in a position of authority, either those who had legitimacy or those who forced themselves on us by virtue of the way and manner they became our leaders, have no respect for law and order and rule of law.
So in that context, do you think it is possible? I mean, that's to some extent what this Justice Summit was trying to do. I'm just going to fit this in so you can continue talking. But that's what this summit was trying to do in a sense, to try and get to a stage or start the process of getting to a stage where it'll be possible to regulate the actions of Nigerian politicians, including the highest ranking ones, through law and law enforcement, such as what we're seeing happening with Donald Trump in America.
Charles, let me say this to you. That in principle and in law, we operate what we call the rule of law. But in practice and in application of this rule of law, we are not operating the rule of law. And the reason is very simple, because those who are operating the laws have no respect for the law they are meant to operate. Take, for instance, in our electoral jurisprudence, show me where it is written in any of our electoral laws that a politician should snatch ballot paper. It's not there. Show me where it is in any of our laws that a public officer who took oath of office to defend and protect Nigerian Constitution should, in the guise of performance of his functions, either as executive, legislature, or judiciary, desecrate and defecate that constitution in the performance of his duty. Show me where it is in our laws that a public officer will dip his hand in the public treasury and loot the public treasury dry to the prejudice and detriments of the downtrodden people and economic development of Nigeria. If you look at chapter 3 of Nigerian Constitution, go and read it very well. It talks about the beautiful economic equalities, economic advantages, ownership of industry, good road, good this, good that. But when it comes to enforcing and doing what you are supposed to do, mark you, there is no public officers in Nigeria, either in the judicial sector or in the legislative or executive branch of government, that does not subscribe to oath of office and oath of allegiance to protect and defend the Nigerian Constitution. Ask questions. How many public officers are really defending the Nigerian Constitution? The Nigerian Constitution is supreme. That's what we said. Right. Section 1, subsection 1, proclaimed that the Constitution is supreme. And that Constitution says when a judicial officer gives a decision, it is the duty of everybody, including the judiciary themselves, to enforce that order. But Charles, I can tell you, speaking from the benefit of hindsight and a lawyer, that it is one thing to get judgments in Nigeria, it is another thing to get the fruit of that judgment. Right. And indeed, we have made nonsense of the existence of judiciary by our attitude, by our conduct, by the way we practice, by the way we do things, by the way we, even as legal practitioners, some of our legal practitioners have, with all respect, become an obstacle
Right.
to
They become part of that very system that
good.
you're
My first reaction is that we need to amend our attitude. You made reference to President Donald Trump of United States of America. No matter how anybody perceived the man to be very powerful, have you heard of any objections to jurisdictions that he has not been served the criminal processes, and you are chasing the shadow of service and leaving the substance of the allegations of the interference is it June 6 or whatever of electoral interferences in that country? Because January 6th. So Americans have institutions. Nigerians have institutions in name,
right,
but we pay allegiance to individuals,
right,
occupants of the office.
Let me come in here, because, I mean, there is an inherent paradox, isn't there, that the legal system is designed to replace the idea that might is right, and that the political victor defines the terms of victory. But the only way that the laws can be enforced is through the might of political power. And if you don't have the power, you can't enforce the law. And that's the paradox, isn't it?
Yes. Now, those who have political powers have no respect for law. And like I have said, and I keep saying...
But that's the point I'm making. That,
yes.
That however they get the power, you still depend on them.
On them to
ensure the enforcement of the laws
what I think,
and the reform of the system.
What I think I should call on President Bola Ahmed Tinubu to do is to, for himself, show the example and be born again, so to speak, in quote, by living as an exemplary leader who does not condone or give protections and appearance of protections to those who are loyal to him.
Yeah, that's an important point.
That's the first thing we need to do.
Yeah.
So when we make examples of those who violate the law of the land, irrespective of their political affinity, political affiliation, and if the President Ahmed Bola Tinubu, for instance, begins to make example from his close allies who may have been alleged to have committed one infractions or come against personal law of the land, and that example is transparent, not rooted in political how do I put it now? Political revenge,
right,
or in order to cow political opponent from saying what you needed to say. So I suggest, therefore, that the anti-corruption agencies should be given unfettered opportunities, not only to investigate, but to prosecute and bring the perpetrators of those who are making this country ungovernable. Either they are in power, or in their business sectors, or in any department,
and the key point
without interference.
Right. The key point that you made there is that they should be given the power.
Yes.
So would it be fair to say that the Nigerian judiciary, the legal system, the courts aren't built on anything other than some version of politics, that they have no, as the way you have described it, that they have no inherent enforcement mechanism without ruling power politics?
Charles, you see, this topic is not a topic to be discussed within the spirit of the time you want us to talk about.
Well, we have to try.
If we look at the judiciary itself,
circumscription.
If the foundation be destroyed, there is nothing that the righteous can do. Let us go back to the genesis of the judicial recruitments. When you have a man or a woman who begged to be appointed, it was late Chief M.K. Abiola that made a profound statement that the hands of the giver is always on top. So until we refine the process of our judicial recruitments, and we have lawyers, men and women of impeccable character who cannot be intimidated by the past ways they come to power or come to the throne, you are not likely to have a judicial officer that is bold, courageous. Let me say this.
The fact is that we don't have that.
Yes.
That's why I say that's why I'm asking you, because you're an advocate of this.
We need to go back to the roots of the purity of the profession. Let there be no person lobbying for anyone.
I understand that, but you're not going to waive. I mean, this isn't a Harry Potter sort of show. You're not going to be, I mean, not this program, but Nigeria. You're not going to wave a magic wand and get what you're asking for. So what I'm asking you is this: if the judiciary and the legal system and the mechanisms of justice are always in the domain of politics, is there anything that can be accomplished within that? Is there a way that the courts, for example, can work successfully within that framework? Because we're nowhere near that stage that you're talking about.
In principle and in theory, there's separation of power. What I will then say is that those who are currently manning our courts in the various states must first have Nigeria at the back of their mind and strive to engage and take back their independence. Because in law, the judiciary is independent. In theory, the judiciary is independent. It's the practicability of the independence of the judiciary. And in doing so, it requires boldness of the judex. A judicial officer must be bold, and it requires the boldness of the various heads of courts.
I wish I had the power. I'd make you the.
So, if the various chief judges of Nigeria, the chief justice of Nigeria, all the heads of courts come to a conclusion that all is not well with the justice delivery system, things are going awry. And why do people begin to talk about judges? Why do they look at us, the legal profession, as the problem of Nigeria? It is because...
Rather than the solution.
Rather than the solution. It is because we have allowed our independence to be trampled upon. And I keep saying that the judicial arm of government is the strongest arm of government. And I say this with all sense of responsibility because we are the ones that have a defined qualification. And you cannot become a judge unless you have gone through some rudiment of training. And nobody can just remove you because there are procedures to remove a judicial officer. A judicial officer is not like a political appointee that can just be removed from his office. So all is required of those who are now currently in position to adjudicate is 1, boldness, 2, transparency, 3, interpretation of law that meets the exigencies of Nigeria, that create economic viability, atmosphere for business to thrive, for economics to grow. But where a judicial officer in the functions of interpretation create a roadblocks to attainment of justice and deliver judgment devoid of justice, then the general public will become automatically very uncomfortable with such judicial process. So my suggestion, therefore, is that the various heads of courts, in consultations with the leadership of other leadership of the legal profession, I mean the bar and the bench, must now come together to know that all is not well. And it is better to admit an ailment and find cure for it than to persist.
Haven't they done that? I mean, wasn't that what they were saying at that?
That's what they have said. Then let us prescribe the medication. First, if there are judges and lawyers who have brought the name of the legal profession into total disrepute, machinery should be set in motion to weed them off. 2, get lawyers and other lawyers and other lawyers of impeccable character to replace those who are supposed to be replaced. You must have heard of Justice Shaw panel. All these panels, Kayode Shaw's panel, all these panels that were setting up, let there be an internal mechanism for the judges, what I called the Truth and Reconciliation meeting, where it will involve only the legal practitioners, both the bar and the bench. Let us look at ourselves face to face and speak to us. Charles, the practice of law in Nigeria is what has rubbed on the nobility of the legal profession in Nigeria. If we must restore confidence in the people, then the manner in which those who go to court, those who adjudicate, practice and dish out judgments and order must be carefully looked at by the leadership that is self above board.
That is a very good point, and that makes a lot of sense. But of course, it works in both branches. It's got to be, because it's got to be both the judiciary or the judicial arm of government and the executive. Because in order to keep up, I might call it at the moment, the myth that the courts are working, we're seeing members of the executive doing everything they can to get their own man or woman to be a judge. I mean, that has become important for the politicians, so that it puts the law on their side in the public records. In other words, it gives a veneer of legality to whatever it is they do, so that people can't say that he or she didn't win in the courts. You see what I mean? So,
Charles, when you heap the blame only on the executive,
I'm saying both.
When you heap the blame only on the executive, you are also not fair that the judicial arm of government may have its own blame.
No, I'm saying it's both.
So all we need to do is that let us have a defined boundary beyond which nobody can cross. Now, I know of a principle of law which is of considerable antiquity, that in the decision making and whatever you do as a lawyer, as a judge, you must not give appearance of impropriety. So, in a situation where those who have responsibility to deal with members of the profession appears to deal with those who are alleged to have come in contact with and violate the principles of this not giving appearance of impropriety, to supporting them under the theory of a right that is not coterminous with the purity of justice. That's where we have problem. In those days, Charles, you recall that when there is an allegation against a judicial officer, such a judicial officer does not insist to sit on the bench. Indeed, I have heard of judicial officers in those days coming to court that Charles and Okutepa had approached me in this matter before the court. And
therefore I recused myself.
I'm recused myself.
Yeah.
I recall in 1995, may he so rest in peace, my Lord Honorable Justice A.J. Aboyi Kongbe was to decide a matter involving the late Issa Odoma and then ACB. My Lord came to court and said, well, let me disclose that myself and Issa Odoma were classmates. I want to recuse myself from this matter. Today, you hardly can find a judicial officer. We all say, no, my Lord, we know you. We know your integrity. We know your credibility. We have no problem whatsoever, merely being a classmate. And he gave a decision that stood the test of time up to the Court of Appeal. Before himself went to the Court of Appeal. The point I'm struggling to make is that when we have lawyers and judicial officers of impeccable character, those who cannot compromise the purity of the code of conduct, Because like I keep saying, the code of conduct for judicial officers and code of conduct for lawyers are rooted in morality. They are not code of conduct rooted in legality. There is a world of difference between morality and legality. And once we begin to bring in legality to overshadow morality, that's where the purity of legal system started dwindling. So we need to have judges, lawyers who first of all have respect for the code of conduct. And when there is a judgment, and I love one of the recommendations that was made by the Senate President, that is that why should we seek the consent of the Attorney General, either of the state or of the Federation, to execute a judgment? After all, Section 6, subsection 6 of the Nigerian Constitution gives the judiciary power to do what it needs to do. And execution, according to my Lord, Honorable Justice Ogundere, is a compendium of judicial power. So if a judicial officer gives a decision, and then you are going to Attorney General for purposes of consent before you can execute, who will give you consent to slap his wife?
It makes nonsense of the
whole thing. It makes nonsense of the independent or the judiciary.
Yeah.
For that recommendation, I made a further suggestion that there should be an annual budget for judgment enforcement to be domiciled, and the money released to the various chief registrars of the various high courts, deputy chief registrars of the Court of Appeal, and that of the Supreme Court. That money will be kept there. Once there is a judgment and there is no appeal or there is no stay of execution, a judgment creditor must be entitled to the
That's a good recommendation. We've got literally seconds to go before we have to end this fascinating conversation with you. You must be very frustrated. I mean, listening to you talk and listening to you and all the things that you feel are going wrong that ought to be done to fix the system.
Legal practitioner of
that would prevent
not feel frustrated in the manner practices, the practice of.
I mean, it's obvious that Nigeria, to some extent,
forget about the judicial officers first.
Very
go
briefly.
To the registry.
Right.
Go to everywhere.
No, you've made that point. I mean, the point is that overall, because it's not just the judiciary, it's the Nigerian people. I mean, this country, people in this country are living in a Hobbesian world. If you were might against might is walking all over them.
In this country,
until you reform
in this country, Charles, even the downtrodden are lawless. The mighty are lawless. Go to the road now. You will see some people selling on the road, carry mirror, put on your face, knock your. It doesn't happen in the countries we try to copy it. So there is this spirit of Nigerians in virtually everyone. And until we deal with that spirit of Nigeria in us, let's stop deceiving ourselves by trying to say this is not how it's done in America. In America, in the UK, in other advanced countries, there's what I call the terrorism of law. Once you violate the law, be you the president, be you the chief justice, be you the governor, former governor, you are going to face it. But today, we seem to think that in our country, those who have the privilege and opportunity to decide what is right, chose to decide what they perceive to be what is right according to their estimation, not according to what is right in the generality, in the perception of the generality of Nigeria. And it is because there is a great deviation from what looks like the truth and fact that Nigerians are now beginning to think that lawyers and judges are not good. But let me tell you that I belong to the noblest of profession. And the profession of law is noble. It is the practice of law that I have challenged.
And that's an excellent way to end this brilliant conversation. Thank you very much indeed. Jibrin Samuel Okutepa is a senior advocate of Nigeria and a keen supporter of judicial reform. Thank you ever so much.
Thank you very much, Charles, for bringing me.